When attempting to determine Scotland's constitutional status within the UK, the first thing to consider is that the UK has no constitution, at least not in the sense of having a specific codified document. Certainly, there are a loose collection of statutes, laws and precedents that are claimed by constitutional experts to amount to a constitution, yet there is no written document. So, without a written constitution, where exactly does sovereignty lie? Well, if the UK Constitution is claimed to be defined by its laws and statutes, then one would naturally assume that sovereignty would have been established by the laws and statutes published by Westminster. Yet when you search for the term sovereignty in the records of the National Archives, under the parameter all UK legislation, excluding originating from the EU, the only listed results relate to 3 acts from the pre-1707 Scottish Parliament. The simple fact is this: there is no act of the Westminster Parliament relating to the matter of sovereignty, nor is there anything in the Treaty of Union or in the subsequent Acts of Union. Constitution experts will of course assert that sovereignty in the UK is not about laws or statutes or even the Constitution. They'll tell you that sovereignty is all about legal precedents and the notion that Westminster's parliamentary sovereignty holds sway. And indeed, if you search the records of the Supreme Court, the UK's highest court, there are numerous references and rulings with regard to sovereignty. In one such judgment, in the UK withdrawal from the European Union Legal Continuity Scotland Bill, it refers to Section 28 of the Scotland Act and states that notwithstanding the conferral of legislative authority on the Scottish Parliament, the UK Parliament remains sovereign. There are 2 key factors to take into account here. Firstly, and importantly, sovereignty is not actually mentioned in the Scotland Act. Secondly, the Scotland Act was created by the UK Parliament, the very body that may not actually be sovereign, at least in relation to Scotland. And there are court cases that suggest that this could be the case. For example, during the constitutional case of McCormick versus Lord Advocate, held in the Court of Session in 1953, Lord President Cooper stated that the principle of unlimited sovereignty of Parliament is a distinctly English principle which has no counterpart in Scottish constitutional law. In some respects, the issue of sovereignty has become something of a vicious circle. Here's how it works. Westminster, acting as a sovereign body, creates the Scottish Parliament and decrees it to be subordinate. Then Westminster creates the Supreme Court to its own specifications. The Supreme Court in turn rules that, due to a previous act passed by the Westminster Parliament, Westminster is the sovereign legislator of Scotland. Therefore, in the eyes of the law, the UK Parliament simply acts as a sovereign body, and the precedents it sets in doing so makes it sovereign, according to court rulings. Yet if this is the case, then why can't the Scottish Parliament similarly set its own precedents by acting in a sovereign manner? In 1988, a document called A Claim of Right for Scotland was produced by the Campaign for a Scottish Assembly. It stated the sovereign right of the Scottish people to determine the form of government best suited to its needs. The document was signed by all of Scotland's then serving Liberal Democrat MPs, and all Labour MPs bar one. It included the signatories of a future Prime Minister Gordon Brown, a future Chancellor of the Exchequer Alistair Darling, and 2 leaders of the Liberal Democrats, namely Charles Kennedy and Mingus Campbell. Noteworthy is the fact that the Scottish National Party didn't sign it. And the reason for this is that whilst the claim asserted the sovereign right of Scotland to choose its own form of government, it was under the somewhat contradictory precondition that the government itself wouldn't be sovereign. Of course, at that time, Scotland was a predominantly unionist voting country, and as such, the Campaign for a Scottish Assembly was a product of the political landscape at that time. Yet over 3 decades have now passed since the claim was signed, and both the political landscape and the public mood have been completely transformed in Scotland. The idea today that Scotland should have the sovereign right to choose its own government, but not a sovereign government in itself, now seems patently ridiculous.